So I will be chairing the next panel. It's very wonderful to transition from the speaker role to the chair role, because I get to ask perhaps many questions abusing my role. Let's see. But without further ado, I will introduce the final panel of today's conference, Global Perspectives on Facial Recognition Technology. And we have a fantastic lineup of speakers. So let's start immediately by introducing the first. So we have Professor Hurwitz from the University of Nebraska. So Justin is a professor of law and the Menards Director of the Nebraska Governance and Technology Center at the University of Nebraska. His teaching and research focus is on the regulation of technology with an emphasis on communication and information technologies. His work has been cited by regulators, including the U.S. Federal Communications Commission and the Federal Trade Commission, and he has testified before committees of both the U.S. Senate and House of Representatives. Professor Hurwitz received his law degree from the University of Chicago Law School, and he also obtained a master in economics from George Mason University. He will be talking about challenges in regulating FRT in the US. So please, Justin, the floor is yours.
Okay, wonderful. I am sharing my screen. Hopefully you all can see that. If I can get a thumbs up if you can see that. Great, and now I know that you can hear me as well. So it's a pleasure to be speaking with you all. I recognize that it is a little late for many of you. We are coming up on the end of the day, so I will jump straight into it. I need to start by acknowledging and recognizing my colleague, Malin Fiddler, who has joined me on this project. She is also a professor, assistant professor of law here at Nebraska. And she focuses on criminal law. She's not able to join us because she is actually in Ghana right now for a cybersecurity conference where she is speaking. So I believe there's a saying, and now for something completely different, turning to the other side of the Atlantic, I'm going to talk about the landscape for facial recognition technology regulation in the United States. And I'm going to start with a little bit of background on the various legal institutions at play, because this is the only chapter in the book and discussion today of US regulation. And like Europe and like other parts of the world, we have our own idiosyncrasies in our legal institutions. So, a little overview of American legal institutions relevant to facial recognition technology regulation. We need to start by dividing U.S. legal institutions into federal institutions and the states. So we, the United States, we are the United States. 50 states make up a federation that is the United States. And each of those states, plus a couple of other jurisdictions, have their own idiosyncratic regulatory institutions and ability to regulate in various ways. So starting at the federal level, this is what most people naturally think of as regulation in the United States, including most people in the United States tend to focus on congressional legislation as the primary source of regulation. So our Congress can draft laws. Sometimes they actually do it. It's actually quite rare that they do it. Those laws need to be approved by the president, and we'll talk more about some of the quirks there. The president, the executive, also has a fair bit of authority to regulate directly, primarily through the machinery of the state. So we very frequently see, for instance, technology regulation in the United States being accomplished by decisions, procurement-related decisions for the technologies that the United States government will purchase or will not purchase. So the Department of Defense, for instance, is a very significant purchaser of technologies. If they, through their procurement rules, which the president can, in some cases, dictate, say, we will not use technologies that incorporate certain features, then a lot of manufacturers are going to not design technologies that incorporate those features. We also have administrative law or federal agencies like the Federal Communications Commission and Federal Trade Commission. A brief note, since I have heard some discussion of this today, the Federal Trade Commission here has recently announced the advance notice of proposed rulemaking relating to commercial surveillance and data security. That is a very early regulatory proceeding. I personally expect that it is not going to result in any rules being adopted. And if it does result in rules being adopted, I can almost guarantee that they will be rejected by the American courts. A topic that I could spend and have spent hours talking about. I won't say more about that right now, but it is, given the complexities of our rulemaking system, I actually just heard from Malin, my co-author in Ghana, that she has been talking to people in Ghana who are telling her that it's their understanding that the Federal Trade Commission has adopted rules, and also that our Congress has adopted new privacy regulations through legislation called ADPA, which you might have heard of. That legislation is almost certainly not going to be adopted, and the Federal Trade Commission's rules also are almost certainly not going to go into force. So that illustrates a lot of the complexity. We also have our Constitution. I'll say more about that in a moment. Every state has its own version of all of these institutions, legislatures, regulatory agencies, an executive, generally a governor, their own constitutions, which sometimes have different rights than the federal Constitution. Another thing that I'll say, and also every locality in the United States has some ability to adopt some of its own regulations. So, the federal level issues, let's start with really the most important set of issues, the federal Constitution. The federal Constitution in the United States is mostly geared towards regulating the conduct of the government and puts in place very permissive rules for individuals, including corporations and firms. So under our Fourth Amendment, if the federal government wants to engage in a search and seizure, it needs to have probable cause, possibly go to a court and get approval for that. On the other hand, if the federal government wants to regulate individual speech, it's going to face very heightened judicial scrutiny in order to be able to do that. This is very important both for privacy law purposes. Those of you who study privacy law and have done comparative studies probably know that the European approach to privacy values is fundamentally different from the American approach. And this translates to the discussion of federal facial recognition technologies. We heard some discussion previously as well of the so-called third-party doctrine. It wasn't in that term, but the basic idea in the United States is that once you put your information out into the public, it's in the public. You've foreclosed, you've given up your right to control it. If you don't want people to see your face or scan your face or to know who you're talking to or where you're going about, stay in your house. Once you go outside, the constitutional principle here, I'm not necessarily defending it, I'm just articulating what it is. Once you choose to go out into public where others in public can see you, others can see you, and they can use that information as they will. There's also a really important constitutional doctrine in the United States called standing. It's not unique to the United States, but there have been some recent judicial opinions at the Supreme Court. Standing relates to the circumstances under which you can take a issue to the courts. And standing requires that there be some concrete harm. And the United States Supreme Court has indicated that privacy-related harms and harms to dignity or speculative risks about how technologies could be used in the future, possibly to injure you, might not be sufficient to satisfy standing requirements to even get into court. Turning to Congress, Congress can regulate private uses of technology, but there are limits, most notably when you have First Amendment style issues that come into play. Generally, when we see regulation in these sort of areas, Congress doesn't focus on prohibiting the use of a technology. Rather, they focus on things like ensuring notice that the technology is being used or access to data about the technology. We see that also at the state level. The big exception there is Congress can regulate the government's own conduct as opposed to the conduct of individuals. We saw this, for instance, we heard some discussion of post-Watergate and post-wiretap era developments in the 1970s and 1980s, where Congress adopted laws called ECPA, the Electronic Communications Privacy Act, that restricted government access to communications, electronic communications, including telephonic communications. Politically, we're at a gridlock in the United States between our Republican and Democratic parties. It's just very difficult to get anything done. At the state level, issues that come up, rules tend to be inconsistent between states. I'll talk about that in a moment. And they, of course, lack national scope. If Illinois adopts a law, if Nebraska adopts a law, that nominally only applies to residents of or companies doing business in those states. And where rules conflict with each other, you can get really complex issues. And where rules conflict with federal regulations, you get what's known as preemption. If the federal Congress adopt rules that apply to an entire field, or that create specific conflicts with specific state regulations, they will preempt the state regulations, and effectively those state regulations cease to exist. Okay. So some examples of FRT regulation in the United States. At the federal level, we have some things that have been proposed, some things that are actually happening. Some discussion of limiting law enforcement access to private FRT systems. This is probably the biggest issue that is ongoing and where I think things are most likely to happen. The basic concern is that if I'm a private company and I'm running an FRT system, I have access to consumer data, the federal government might not be able to obtain access to that information on its own without getting a court order. But if I already have that information and the government asks me for it, the Constitution doesn't prevent me from giving it to law enforcement. So we've seen several instances of law enforcement just asking companies for information and companies handing it over. And it's likely that Congress is going to adopt rules that say, hey, law enforcement, you can't do this anymore. Curiously, those rules generally won't prohibit me from giving that information to law enforcement. And if I do, law enforcement can use it. I might face fines. This is how the Stored Communications Act, for instance, works, but law enforcement can use it. There have been several proposals to limit the government's own use of facial recognition technologies. This legislation hasn't gone anywhere, but our Government Accountability Office has been doing a lot of studies to assess the extent to which government agencies are using FRT. Unsurprisingly, it's mostly being used for security purposes in buildings. No surprise there. Another specific example of FRT regulation, the Everalbum case. The Federal Trade Commission did bring an enforcement action against this firm, Everalbum, which had said, we're not going to use FRT for our services unless you opt into it, and then they used it anyhow. Importantly, and this is how things very frequently happen here, the Federal Trade Commission was not regulating the FRT technology. They were responding to a deceptive act or practice. Everalbum said they were going to do one thing, they did another, they lied, and that can be regulated. At the state level, we have seen a number of really interesting things going on. Again, we have a distinction between regulation of private actors and state actors. Illinois has a law called BIPA, the Biometric Information Privacy Act. This actually is a relatively old law going to the mid-2000s, and it's been held to apply to facial recognition technology. Facebook, for instance, no longer uses any of its facial recognition. There has been some litigation that resulted in settlement against Clearview AI, which I expect many of you are familiar with in Illinois. California, the CCPA also has similar regulations. In both of these cases, the regulations don't prohibit the use of FRT. Rather, they require notice and consent frameworks, access to data and information, right to correct incorrect information that would go into the use of these systems. And that's probably to the extent that we get specific regulations regulating FRT specifically, the approach that we'd see. We've seen a number of states adopt regulations of state use of the technology, and there's a wide range of regulations here. The state of Vermont, for instance, has prohibited state actors, law enforcement primarily, from using facial recognition technology in any case except those relating to child exploitation cases. The state of Oregon has taken a very different approach. I just blanked on the only use that they've outlawed, but they allow law enforcement to use facial recognition technology for any use except for only one. Yes. I've got about 2 minutes left.
Yes, exactly. Yep. Thank you so much. Thank you.
And the state of Virginia is another example. They've had some regulations and they've changed dramatically over time. Again, at the state level, we also have a lot of localities. These are cities, towns, counties, about 5,000 of them in the United States, and these are all over the place. Some have prohibited the use of FRT by their police forces. Others have done nothing about it. I thought I'd had one more slide, but I don't. The last thing that I'd say, very similar to the discussion about things in the United Kingdom, you might think there's a lot of skepticism and concern about facial recognition technology, and our Constitution embeds a lot of concern and skepticism about the government. So you'd think we want to prohibit use by the government of this really intrusive technology. A lot of security state concerns, however. Politically speaking, anytime we start discussing limiting law enforcement use of these technologies, well, these are used in missing child exploitation, sexual abuse sort of cases, and that is a very powerful argument in the United States, as it is many places, and I expect it is very unlikely that we'll see broad-based bans of the use of this technology by law enforcement, if for no reason other than to preserve use by law enforcement in those cases. Thank you all for your time. I look forward to any questions or discussion.
Thank you very much, Gus. It's so interesting to see how different systems have also challenges, not simply on the substance, I would say, of the regulation of FRT, but also even before that, even before getting to the substance, on the procedure on how to achieve regulation. So I'm sure that there will be many interesting questions on this. So let's move on. Thank you very much, Gus. And let's move on now to the following presentation. So I was notified by one of the speakers that we won't have two speakers, but just one. So, but he will, of course, cover both parts of the presentation. So it's a great pleasure to introduce Nicolo Zingales, who he's a researcher at the center, he's a professor, professor of Information Law and Regulation at the Law School of the Fundação Getúlio Vargas in Rio de Janeiro, where he coordinates the e-commerce research group. His work on digital rights spans across data governance, fundamental rights, and platform regulation. He's a founding member of the My Data Global Network, and he leads its Brazilian hub. And he's also an editor of Media Law. He's also an affiliate scholar at the Stanford Center for Internet and Society, a research associate at the Tilburg Institute for Law, Technology and Society, and an extramural fellow at the Tilburg Law and Economic Center. He holds a JD from the University of Bologna and a PhD in international law and economics from Bocconi University. Nicolò is going to talk about regulating FRT in Brazil, legal and policy perspectives. So, Nicolò, it's a great pleasure to have you with us. The floor is yours.
Thank you, Julia. Thank you, the organizer, for a very nice initiative. I've been learning a lot through the debate today. Apologies for the long bio. Also, I didn't realize it would take so much time of the limited time we have for presenting the paper. So let me share the slides I've prepared. This is joint work with Walter Gaspar and Luca Belli. So we've been asked to contribute to the project by bringing the perspective of Brazil on the regulation of or the lack of regulation of facial recognition technology. Let me just play from the first slide. Okay, it's a little bit slow. My screen is frozen. Okay, there we go. So I'm gonna just give you an overview of the cases that we have knowledge of use of facial recognition technology, mainly looking at what the literature has collected, and then we will also try to give an overview of how the existing legislation applies to this, and mention some of the legislative proposals. And finally, just a very brief analysis, as this is ongoing work, over the adequacy of the existing framework and what can be done to improve it. So we have a wide variety of cases that were reported involving facial recognition technology, mainly in the public sector. And this involves both the state and the federal level, and also some municipal uses of artificial intelligence and facial recognition. It depends a lot on the resources that the states and the municipal government have. So we see some of the famous, uses being done in cities like São Paulo and Rio de Janeiro. And we have less knowledge about uses in more peripheral states. And we have even less information about private use of facial recognition technology. Basically, the big issue that is affecting regulation and use of FRT in Brazil is the lack of public discussion, the lack of information over how the databases are constructed, over the effectiveness of the systems, and generally, the accountability of the actors over the use of these technologies. So these are the main areas that we have found in our research. So the main use, as it has already been discussed quite a lot today, is for public security purposes. But here in Brazil, actually, we have also a lot of use for the purpose of monitoring attendance in schools, as well as for public transportation passes, because some fraction of the population receives free passes to bus and other transportation means, and they tend to be transferred from one person to another without having the right to do so. So there's a lot of also enforcement around that. Border control, that's another area where it has been used, and it's increasing to be used. And then we have some private uses that were detected with regard to the ad placement, and also to understand the reaction of customers in retail outlets. And also a more less concerning use has to do with one-on-one authentication of individuals. So a lot of banks and e-commerce websites are using facial recognition in that sense. The famous cases were all around 2019. The most famous one involved a public concessionary for transportation services, in particular of the metro, of the subway system, where they installed a facial recognition system to serve ads. And this was declared illegal according to consumer protection law, mainly because of the lack of information and the forced consent of consumers. And a fine of about $20,000 was imposed. Metro São Paulo is an ongoing case, also regarding the subway system, but this time for security purposes. And it has been grounded to a halt. The procedure is ongoing, but the preliminary measure that was adopted was that since there is insufficient information over how this data are being collected and safeguarded, this cannot be implemented yet. Some uses of FRT for security purposes were done in the Rio de Janeiro Carnival. There was a big first trial in 2019. And in parallel, we saw also the same happening in Bahia, in another famous carnival. And what was more concerning about this latter case was that the governor announced that he would like to connect the network of various private facial recognition systems that are in place in buildings, banks, and many other private spaces to the public system. And we are not sure whether that has happened yet and what are the conditions for that to happen. Here, there's just a map of how it's spread out. It's mainly in a few states, as you can see from here. The main use, as you can see from the first icon, has been for public transportation enforcement, as I mentioned earlier. The second one, security purposes. And then for public education purposes, the third one. What has been noticed also in this literature is that it has tended to increase a lot around 2018, 2019, and we have a lack of efficacy over the systems. Perhaps they have not been sufficiently developed, but the results so far have been that a lot of it has been spent and not as much in terms of returns for the public institutions in terms of effectiveness of their policies. And also there's been a quite disparate impact in terms of the population that has been affected for criminal prosecution. 90% basically has been Black population. Now, coming to the normative framework, the main instrument is data protection law that was approved in 2018 but entered into force only in 2020. And here we have a few key provisions. One, as in the GDPR, recognizes the sensitive nature of biometric data that therefore must be processed only for a specific and limited set of legal bases, which include consent and a legal or regulatory obligation. The data processing principle, they stress the importance of non-discrimination, but there has been lack of enforcement, I should say. The authority has very few resources. It has just come out with a procedure in order that it will follow to impose fines. And so far, no fine has been imposed. And also a lack of guidance can be observed with regard to several of its provisions of the data protection law, including how to implement non-discrimination, as well as how to anonymize data, and various others key provisions. One of those is also the right to revision over automated decisions. Here we have no clarity over whether this would involve a human revision, as it is the case under the GDPR, and also what it means to provide an explanation to the data subjects. One peculiar provision that we have here is not available in the GDPR is this shared use of personal data between either public entities or between private and public entities. Basically, it requires that an instrument is in place, a legal instrument like an administrative act that enables this sharing, but there are no requirements regarding what needs to be there in this administrative act, which could imply, for example, the contracts between the administration and a third party. But the biggest problem, the biggest flaw here is that the data protection law doesn't apply to public security, national defense, safety of the country, or crime investigation and repression. So all this is out, and we have no legislation that regulates that at the moment. There is a pending bill, but at the moment, this is what we have. And on the other hand, the authority could request a data protection impact assessment for this kind of activities, but it has not done so so far. It has issued some guidelines regarding, the need to marginalize consent when you're dealing with a public institution, because there is this obligatory nature of the relationship. I mean, there is no other way to deal with the administration. The key principle that they say is with regard to the sharing between one administrative body and another is that they need to comply with the purpose limitation and the compatibility of the original purpose. Now we have some new legislation that has been passed in 2019 that is relevant to mention. One is being currently subject to a constitutionality challenge. It involves the ability precisely of the public administration to create a unique database that involves, for example, the tax system able to connect to the other services of the public administration, and basically put it all together without the consent of the data subject. And another legislation laid out the incentives, so transfer some funds to local authorities in order to fight violent crime. And among those, there is a provision to use these funds for facial recognition technologies, and requirement to conduct periodic assessments over their efficacy. So this is good news. Now, with regard to the proposals, we have a lot of proposals on FRT at the state level. We have a little bit of a jurisdictional challenge because security is a state issue, but the data protection is a federal issue. So it's not clear how facial recognition technology will be regulated, but so far we have a campaign that has, by civil society that has led to 13 bills in different states. We have a federal AI proposal and a criminal general data protection law. So just mention briefly these two. The AI proposed bill is criticized because it is very principle-based. It does not have concrete teeth and clear obligations. It has been criticized because it came out without any public debate. And because of that, also probably the regime that it adopted of a subjective liability regime is criticized for being too difficult to overcome the burden of proof for the potentially damaged subjects with regard to the use of AI because of the complexity of AI and so forth. So all this discussion has led to the creation of a committee of jurists that is drafting a new proposal on regulation of AI, and it should come out in December this year. And with regard to criminal data protection law, well, it's interesting to see that they impose data protection impact assessment for the use of sensitive data. And when it comes to automated decision-making that affects significantly data subject, it requires that such data protection impact assessment be made public and auditable.
Nicola,
yes.
sorry to interrupt. You have 2 minutes.
Okay, thank you. And there's the enforcer of this law will be, according to the proposal, a National Justice Council, which needs to pre-authorize the use of automated decision-making for criminal purposes. So this is quite a restrictive provision. There is a little bit of potential gap which has to do with the prohibition of data sharing amongst government departments, unless there is a specific proceeding for which it needs to be used some kind of data from another department. It's not clear what it means, specific proceeding, and also what it means, another exception, that the data is publicly available. Does it mean that, if the face is out in public, that the data is publicly available? Overall, there is a criticism for this framework being too harsh. So the authorities are criticizing, but at the same time, there is a huge gap, similar to what Justin was mentioning with the third-party doctrine, about that allows voluntary cooperation by private entities without any significant checks. So briefly concluding the analysis, we also need to take into account the discriminatory impact, the fact that here there's a lot of structural racism already in the country, and so we need a framework that goes beyond simply solving bias ex post. Well, we need to ensure some kind of accountability to be baked in ex ante, and something that we have been seeing is a lot of foreign entities that are wanting to partner with the local governments in order to spur innovation and so on. But there is this concern about where these data are going that are collected from private citizens, of the country. And there is this jurisdictional battle between states and the federal state, as I mentioned. So to conclude, there is a little bit of complaint over the lack of discussion and too lenient approach to risk that is being currently taken. There is insufficient differentiation between different types of FRT implementations, and the huge gap seems to be around, this public-private collaboration and the need to provide more information about that. The MPD, which is the Data Protection Authority, is a key actor and could, issue a lot of guidelines and regulation that would help improve the existing framework, but possibly, some bill that regulates specifically the use of artificial intelligence would also be an important complement to make this framework more conducive to a responsible use of facial recognition technology. With that, I thank you for your attention.
Thank you very much, Niccolò. It's very interesting to see the emergence of these new frameworks across the world, and for comparative purposes, I would be very keen to know more about this when it comes to the GDPR instead. So that was very fascinating. Thank you very much for these three very inspiring, I would say, and rich presentations. So I've learned a lot myself. Now we have Q&A. We have the chance to ask questions to our speakers, if there are any. It has been a long day, and it's incredible to have quite a wide group of people still with us. So this is wonderful. If there are no questions from the audience, perhaps I will abuse my role of chair, and I will ask a question that it's simple, but perhaps also difficult, depending on the answer of the speakers. What's next? So how do you see the future of FRT regulation in your own jurisdiction? And perhaps we can start from Niccolò, if Niccolò is still okay. Great, Niccolò, if you have any conclusive thoughts on this.
Well, nothing conclusive, I think, but in conclusion, in the sense that looking forward, I think that there will be definitely more actions needed by the Data Protection Authority. Also, a lot of what is going to be done depends on the elections here in Brazil that will be in October. And all the bills right now have been on standby because of all the discussions and campaigns around the elections. So I think realistically we'll be seeing in 2023 much more on the regulatory front, as well as the data protection authority that will necessarily have to issue some guiding principles on how to apply some of the rules to, including in the context of artificial intelligence and facial recognition technologies.
Great. I mean, thank you so much, Nicola. I know you have to leave, so I would like to thank you for your presentation and for your participation in this conference. So I will then pass the floor to Gus. Gus, I didn't mean to change the order of speakers, but Nicola told me that he had to leave. So, but please, the floor is yours.
Yep, no worries. So what's coming next? I'll say a couple things. The first, more of the same. We're already starting to see a lot of discussion about limiting government use of FRT. Lots of different things going on at the federal level and in the states and of course around the world, and it's going to be an evolving discussion, but I think there's some consensus around something along those lines. More important, I think it's very likely that we will see federal and state regulations limiting government access to or the government's ability to request access to FRT data from private individuals. That's what happened in the 1980s with telephone information and electronic records, and it's very likely to happen here as well. I wouldn't be surprised, in fact, if we don't start to see that sort of legislation, if we start to see some creative litigation under existing laws trying to argue that FRT data constitutes stored records. That would be a hard argument because they're records created by the company, so they're not records of the consumer or the user. But that's also certainly there. In terms of private uses, I don't expect that we're going to see much in the United States. We will, to the extent that there is regulation of FRT on the private front in the United States, I expect it will be rolled into broader privacy discussions, and it probably won't be around prohibiting the use of these technologies or their development. Rather, it will be around providing consumers with information that they are being used and possibly access to records and information about them, very similar to notice and consent and right to correct access to information style regulations that we've seen around the world. One last thing that I didn't mention that I think is really important for us all to have in mind, of course, is there is the ongoing global conflict between the United States and the European Union over Schrems.
Of course.
But and the Schrems litigation hasn't been about FRT, but a lot of the companies, not all the companies, nearly in the same way that much of the big tech industry has been dominated by American companies. There are a lot more players globally than just American firms when it comes to facial recognition. But the conflicts between global companies trying to abide by various countries, various regions, differing regulations, we've yet to really see that bubbling up in FRT, but I expect that at some point, as different regions and countries do start to regulate more, that we're going to see more conflict there.
Thank you very much, Gus. I mean, you raised very rightly so the point about Schrems and how this could shape future regulation in the US when it comes to FRT, and that's also a very interesting point. So thank you very much. I would have so many questions on this myself. So I don't see any further questions. So I would like to wholeheartedly thank all the speakers of this panel for shedding further light on what FRT technology means in their own jurisdictions and what kind of issues it has raised from a legal and a governance perspective. I think that we complemented the discussion that we had already in the previous panel very, very nicely. So once again, thank you very much. I think that it's also time to conclude the the conference proceedings. Well, we ran over time, and this is testament to the fact that, everyone was extremely interested and excited to discuss such a controversial topic such as facial recognition technology, with the view to understand its historical evolution, but also its functioning and legal issues emerging therefrom. So I would like to again thank all the participants, not just the speakers, but all the participants for their contributions. And with this, I officially conclude the conference. So thank you very much to everyone, and in particular the conveners for organizing such a thought-provoking event and a beautiful forthcoming volume. Thank you.
So I just want also on behalf of all organizers to thank really all speakers and chairs. Julia, thank you so much for chairing the last session, and all participants for staying with us until the end. It was a very long day, but I think it was really enriching. It is almost 2 a.m. in the morning here in Sydney, so if I can't articulate myself, it's because it was a very long day for me. But I really do not regret a single minute. So already Julia nicely summarized all the different topics that we covered. We also covered so many jurisdictions and so many different perspectives. I mean, it's a lot of information to process, and I think that we will be able to again listen to or read that information in the book that will be published, and that will contain most of his presentations. So we'll keep in touch with all of you, and good luck with your amazing projects, and wish you all a fantastic evening. Good night.